against Advocate Jiba at the time. Correct?
That's correct.
Right. Now you referred him to us. Is that so?
I suggested that he should come and give evidence at the commission. At the inquiry, sorry.
I was fumbling around before the lunch adjournment, and I was taking you to fold G 1.2, but you don't have to go there. I simply wanted to finish off the point that I was trying to make, was that Advocate Jiba had indicated in her affidavit and had confirmed in paragraph 11 that the charges against her stemmed from the fact that she had assisted the police in the investigations against Karinal and had given a statement. And that accords with what you were aware of, correct?
That's correct.
Now, can we turn to the Zuma judgment, which took up the bulk of your cross-examination last week? The allegation was made in cross-examination that Advocate Epstein disavowed any responsibility for the answering affidavit. Why, in your mind, was that?
Essentially, once Mr. Abrams took over as NDPP, he removed me from dealing with anything to do with the Zuma matter. So I was not consulted at all about what happened in the SCA matter. I was not aware. I was not given the papers that the NPA filed to read or to confirm. So,
Mr. Huffman, I think, sorry, you misunderstand my question. As counsel, did Advocate Epstein have a hand in the drafting of your answering affidavit?
at the time, no.
Who was it?
It was Paul Kennedy and Hamilton Manechi.
So, when Advocate Epstein says he had nothing to do with your answering affidavit, he really had nothing to do with your answering affidavit. Isn't that so?
That's correct.
Now, yesterday we had your colleague, Advocate Mohatla, give evidence, and she essentially encapsulated her position as the Deputy National Director as one governed by the Constitution, the NPA Act, the policy of the directives, the Code of Conduct, other relevant laws, and the instructions of the National Director. Do you agree with that?
That's correct.
And so when Advocate Mshay asks you to perform certain tasks, or Advocate Abrams asks you to perform certain tasks, or Advocate Mksana asks you, Mr. Mksana asks you to perform certain tasks, as a deputy, are you obliged to do so? Lawful tasks.
Yeah. If it is lawful, yes, I would say so.
Now, and I just want to understand this in the Zuma matter. You made the submission that there was a review committee, correct?
That's correct.
There was a big debate in cross-examination about the differences which emanated in the review committee in relation to when the charges should be brought.
That's correct.
Was there any difference as to whether there was a case or not?
No.
In relation to the SCA judgment, you repeatedly indicated that you accept the judgment. How must one interpret that? That you accept every factual finding or you accept the ratio?
I accept the ratio, and as I indicated, I accept the fact that some of the evidence that I included, or the criticism of the fact that I should not have included certain evidence.
Now, at the time when that answering affidavit was prepared, Advocate Mshay was an acting judge and you became the department because he wasn't readily available. That's what you said in cross-examination.
That's correct.
I don't want you to necessarily go there, but I want to read you paragraphs 47 and 48 of your affidavit. Mshay proposed that the Minister of Justice appoint an independent judicial inquiry to investigate all allegations and suggest remedial steps to ensure that the abuses seen in the Zuma prosecution were never allowed to occur again. The Judicial Commission would be independent of the NPA, but also have the necessary authority to to compel Mokgoro and Enquiry to cooperate. Regrettably, the Minister of Justice and the President did not see fit to pursue the matter any further. Was that essentially what you had hoped would take place?
That's correct. I thought it was very important that we had to come properly to terms with what had happened in the NPA.
You were effectively told that in the affidavit which you deposed, you had implicated the Minister, a former NDPP, and a number of people. Have you ever been sued by anything?
No, nobody had threatened to sue me, or I think there was some criticism by one of the persons on radio that I heard about, but there's no legal steps have been taken to me for speaking untruths.
And the 3 years have passed.
Long ago.
Now, the allegation, and I want to understand this, Advocate Jiva went from acting NDPP to deputy heading NPS, correct?
You mean after she acted?
After she acted.
I think that's correct.
She created the position NPS when she was an acting, and I think the evidence was that acting NDPP Mokgoro Enquiry was the first person who held that position of the newly created NPS to bring all the prosecutions under one umbrella. And then when Advocate Jiva wasn't acting anymore, she was the DNDP of NPS.
That's correct. Yeah.
Now, as I understand it, and correct me if I'm wrong, as a deputy under Sean Abrams as a national director, she still remained the head of NPS. She was the head of NPS under Mr. Mokgoro, and then she was the head under Advocate Abrams.
That's correct. Although they...
No, sorry, I think she got switched to something else somewhere. Anyway, I'll sort that out with her. Sorry.
Yeah, but perhaps just to say that initially there were 2 deputy nationals in charge of prosecution. So there was one in charge of the specialist units, the SCCU, the Priority Crimes Litigation Unit, and so on. And then one in charge essentially, so it was essentially one deputy dealing with the special directors and their areas of focus, and one deputy dealing with the normal DPPs and the normal prosecution stream. So that was combined under Mr. Abrams, that she became overall head of all prosecutions.
So on the reporting structure as a deputy, all the DDPPs would report to her as the deputy.
That's correct.
Now I want to know if you call for a briefing, be it as an acting NDPP or as a deputy, and the deputy director or the DPP comes to head office and they come and do a briefing on a particular case. And they tell there that you've got insufficient evidence to prosecute. What would that DDP or DPP do? They go in charge or they wait?
I mean, the decision still remains their decision. But in most cases, especially in the early days, we were briefed fairly regularly on the high-profile cases. If there were serious questions or concerns raised, they would go back and try and ensure that those concerns are dealt with. Although, as I say, they probably have the right to continue anyway. But that was the idea, was not to prescribe from the national meetings, because we knew we didn't have the power to prescribe, but we did have some unfortunate cases in early days where the NPA was seriously embarrassed in court, and I think the notion of trying to make sure that there's some interrogation of the prosecution decision before it goes to court in very high profile cases sort of stemmed from some of those experiences.
I did wonder whether the NDPP powers of intervention could actually be invoked before a decision was taken to ensure prosecutorial policy was complied with before the person is charged, or is that always an ex post facto mechanism to be invoked?
I think it would depend very much on the circumstances. Normally one probably wouldn't become aware of such a deviation from policy until defendants have raised it in a case. So I can't think offhand of a place where it became important in a prosecution decision, but I may not be remembering about that.
Well, let's take a Bosasa example, for instance, or another high-profile case. Let's not say Bosasa, but there are regular briefings. There are regular briefings that go up because of the high-profile nature of a case, right? And the huge money involved, or extremely sensitive because of the people involved, and they want to make sure that all the I's and the T's are dotted before they charge. There would certainly be, I'm not suggesting a directive, but there would certainly be a cooperation between the DPP office and the NDPP office. Would you agree?
Yes.
And I'm not suggesting any impropriety. I mean, it makes sense. That's why you have the two structures. Checking whether in practice that's what happens.
In practice, I think it doesn't happen very often, but it does happen.
But we are talking about that exceptional high-profile case where one would expect that level of involvement.
Yes.
Okay. There are two Joubert statements before us. Can you say which one's real and which one's false?
The best that I can suggest is that I was listening in to Joubert's initial telephone conversation with Mr. Molele. Although most of it was in Zulu, so I understood some but relatively little of the conversation. But certainly the gist of what was conveyed to me afterwards by Mr. Molele is what appeared in Joubert's statement subsequently. But if somebody independent is required to say what the initial allegations were that Mr. Joubert made, I think Mr. Molele would be in a position to assist the inquiry about that.
Now, your affidavit in the Cape High Court, the Western Cape High Court, which was before Judge Delamo, it seems the context is, and let's be very frank, was very apparent from those affidavits, is there's no love lost between you and Mr. Abrams. Would you agree?
Indeed, although our relationship didn't really become acrimonious, but no, there was not much love lost.
So, he files an affidavit, you don't agree with that affidavit, you then file an affidavit independently and you make it available to the parties. It's the DA that then brings this application to have that affidavit admitted. Would that be, you are not part of the legal proceedings at all?
No, not at all.
Okay. But I want to take you to one aspect of your affidavit in page 9 of that affidavit, and maybe I can just read it to you. It's not a contentious. At some point, Mr. Abrams takes you out of asset forfeiture and he puts you in LAD. Is that so?
That's correct.
Right. I think at some point, Mr. Nksana had done the same thing to Advocate Jiba, and she spent some time in LAD as well. But my timeline might be out. You then say in your affidavit, he had removed from my supervision as head of LAD a significant number of cases dealing with allegations of unethical conduct by Ms. Jiba and other senior NPA officials, and indicated that he or his personal advisor would deal with such cases. That's in paragraph 28. He then, you say, it had become a situation that almost half the LAD staff no longer reported to me on certain matters although they were still formally on the establishment of LAD. What did you mean by that?
What I meant is that when some of these contentious cases, if I may call them that, were served on the NDPP, you would, I think, issue instructions that they should not come formally to LAD, as is the normal process, and that some of the staff members in LAD would then work with with his legal advisors, Mr. Dawood Adams and Marco Voller, on these cases. I only read about them when they appeared in court later.
And he used people who were part of the establishment of LAD in those matters as well. Is that what you're saying in paragraph 31?
Yes, particularly Mr. Chita, I think.
Now, I need to just clarify something because of certain averments that was made. You spent a considerable time drafting the affidavit which you provided to us in January. Is that correct?
That's correct.
I had made a number of comments and drew the terms of reference to your attention repeatedly.
That's correct.
The final version of your affidavit is yours.
It is.
During the course of our consultations, I had discussed with you the arrests of Garinal, the Celebi matter. Would that concur with your memory?
That's correct.
Did I discuss with you the spy tape saga at all?
Not that I can recall.
Okay. Thank you. I've got no further questions.
Thank you, Ms. Bauer. Do you have?
Yes, I do want to ask certain questions.
Based on new areas which had arisen.
Yes,
thank you.
But Madam Chair, you remember that Mr. Rense did say that he's not closing his cross-examination. He absolutely refused to close his cross-examination because he said that there was no time for him to deal with the other issues he wanted to deal with. I'm not going to raise new issues, but I just if I do, and if there's an objection that I'm raising new issues, may I beg your indulgence because of that possibility that these new issues arose as a result of the fact that Mr. Rense did not finish the cross-examination.
No, when I mentioned new issues, I meant you're going to continue with cross-examination so far as new issues had arisen during examination.
Okay.
During, re-examination. No.
So, thank you, Madam Chair. Mr. Hofmeyer, you have been in the NPA for about 30 years, 20 years, am I right? Short of 20 years.
Just short of 20 years, yeah.
In the years that you've been in the NPA, have you ever signed a single authorization in terms of poker?
I signed numerous such authorizations in terms of asset forfeiture proceedings.
No,
because I was delegated by the NDPP to do so.
But that was not my question.
Can we just get an understanding right from the start that we're not going to fall over each other? You ask a question, you complete your question, Mr. Hofmeyer, you respond to the question, and we give each other the opportunity to do so. Yesterday, Ms. Moroka reminded you that unless we do that, we're going to have a record which we will not even understand, and we need to write a report and be clear about what is on record. Can we get that cooperation? Thank you.
So,
proceed.
So did you hear my question?
There are two types of authorizations under POCA. One is to institute asset forfeiture proceedings, and the other is to institute racketeering proceedings.
Right.
You asked me a general question, that is why I said Um, I had literally issued probably hundreds of authorizations in terms of the asset forfeiture proceedings.
But have you ever issued an authorization in respect of racketeering issues?
Not that I can recall.
In fact, your evidence that there is no committee, there is a committee that vets or that provides a that looks at these matters is actually not correct. From Advocate Jiba, who has in fact done a lot of authorizations that are racketeering, there is no committee that looks and determines whether or not to bring an authorization request to her. There is no such committee.
I have personally engaged on a number of times with that committee, whether it was it was probably before her time as acting national director. But I know there is a committee, and the details I gave came from my personal engagements with people who served on that committee about what the processes were at the time.
You accept that Mr. Mosing, if there was a committee, Mr. Mosing would know about that?
I'm not quite sure when he became involved in the process, but I mean, it's not a matter of contention.
Does it matter when he was involved?
Well, before he was involved, he may not have known that there was a committee, is what I'm saying.
After he was involved?
Involved in
these authorizations. After he was involved in this, Mr. Hofmeyer testified that he believes that Mr. Mosing joined two people who were on the committee. And I'm asking him whether he accepts that if there was such a committee, Mr. Mosing would in fact reflect that such a committee does exist.
I think there was such a committee. Whether it existed at the time, I mean, whether it was disbanded and Mr. Mosing was made exclusively responsible for those decisions is probably what happened. But I can assure you that there was a committee.
You are not able, Mr. Hofmeyer, to assure this committee that, to assure this panel that there was such a committee, because you have no minutes of such a committee. If you have minutes of such a committee, please, we would invite you to bring the such minutes.
I never served on the committee, so I wouldn't have minutes of the committee.
Yes,
but I'd engaged with members of the committee over probably 3-4 years on various cases in which we had an interest. I knew that the committee existed and that they functioned. At some stage, they clearly stopped functioning as a committee.
And your view is that it stops functioning as a committee when?
The first instance that I'm aware of was the authorization of Mr. Boyson.
Ah, Mr. Boyson again. Let's just go to Mr. Boyson.
As long as it arises from re-exam.
I'm aware of the rules, ma'am, and I will if I'm out of order, then you'll no doubt help me with that. Do you understand in the racketeering offences and the scope of criminal liability that is covered under racketeering offences?
Sorry, as I think I said in my main evidence, I was on the parliamentary committee that went to the United States to study the asset forfeiture and racketeering offences and help to write those provisions into law. I won't describe myself as an expert on the details of what should or shouldn't be before a prosecutor, before a racketeering authorization is issued. But I have a fair idea of what the intention of the laws and how it was applied in practice.
Just so we take that away, would you accept that Advocate Chiba understands the racketeering legislation and how it works?
I don't know.
That's very awkward that you don't know. That's a very awkward answer coming from someone who worked with Advocate Chiba for a long time.
As far as I know, she's never prosecuted a racketeering case, which is where I would say somebody has become an expert in racketeering.
Have you ever prosecuted a racketeering case?
No, as I indicated, I did not.
Right.
We
So-
participated in a number of cases where racketeering charges were brought, and for asset forfeiture purposes, we had to satisfy ourselves that they were there properly, that we could make our asset forfeiture application dependent on the racketeering charges, or whether we should focus on the underlying criminal offences only.
Perhaps let me put it this way. Would you say that Advocate Chiba does not know what racketeering offenses involve?
I think there is a difference between the level of understanding of those who are involved in the process of looking at racketeering offences and those who actually prosecute matters before a judge and have to convince them about the details of the elements of a racketeering case. So I would be surprised if Ms. Chiba was an expert in that sense. I certainly wouldn't regard myself as an expert in that sense.
So is your answer that she doesn't understand racketeering, the legislation around racketeering?
I did not say that. I said I assume she knows quite a bit about racketeering, as I
Okay.
did, but that there is a difference between prosecutors who specialize in racketeering cases and their level of knowledge, and those of us who only have oversight or over the work that they do, but are not involved in putting the details together.
I am asked to assure you that she actually is familiar, more than just familiar. She considers herself an expert on the field. She manages a whole group of people who, in fact, are experts on racketeering. Would you accept that assurance?
If she believes she's an expert, I cannot contradict her on that.
I will. I'm surprised by your answer, because I would have expected you to, for all the things you say about Advocate Chiba, to cut a slack when it comes to an important aspect relating to whether or not she knows something about racketeering. Obviously, you are right. You think she knows it at general level. That's your view. But I just want to take
Sorry,
you,
can I respond to?
if you want to.
I think generally, and my experience is that people who have prosecuted a racketeering case and have dealt with the details of the evidence and the minutiae of how an enterprise works or what it is that you require to do it are the experts. Those of us who look at the dockets, see the evidence, and so on, but have not stood up before a judge to to argue those issues, I wouldn't want to call any prosecutor who's not prosecuted a racketeering case an expert. You become an expert by doing the work and dealing with the issues that arise in court.
Yeah, I understand your answer. I think it's clear what you intend to do. But let me just take you to some of the things that you say in your affidavit, which you have, no doubt, you intend to have the panel look at and make the findings that it appears you would want the panel to make. Do you have your affidavit in front of you? Thank you. Now, can I refer you to paragraph 45? Sorry, I beg your pardon. Can I start off at 44? In paragraph 44, you say that even more dangerously, in a number of prosecutions, the NPA has essentially been perceived to be acting on behalf of a faction of the ruling party. Can you show us evidence of a faction of the ruling party that you have presented to the panel, on which you suggest the NPA has been perceived to be acting on its behalf? Do you have evidence that the panel can have a look at, which shows that there is a faction which the NPA has targeted, faction of the ruling party which the NPA has targeted?
I think my proposition that I put forward is based on what happened in a number of specific cases. And those cases mainly involve people in law enforcement.
No.
Sorry, if I can finish my answer.
No, you're not answering my question. That's why I have to stop you. You're not answering my question. I asked you to give us evidence of a faction of the ruling party which you suggest is targeted by the NPA. I didn't ask you to tell us about people who have been prosecuted from the security establishment. I asked you about people.
I don't remember that issue arising during re-examination.
I did not ask any of these questions.
Masuku?
But I understand it does not come from
Re-examination.
re-examination. But it's not. It's an important question which ought to be asked. And if Mr. Arendse didn't ask it, that's because he didn't really have the time to finalize his cross-examination.
No, that was not our agreement. We have agreed that we're going to, and we agreed this with Mr. Arendse, that if any new issue arises during re-examination, you will have a right to cross-examine on those new issues which arise. And I would like us to stay on that course.
Can I then ask?
Otherwise, you're going to start cross-examination all over again.
No, that was not going to be the idea. I was actually going. That's not how I was going to do it. No, I mean obviously I'm guided by. I'm going to be guided by your ruling.
I say, unless I'm incorrect, as I say, I do not recall that issue arising during re-examination.
And I conceded that. I accepted that it did not arise from re-examination.
Which means you cannot cross-examination, because you cannot cross-examine on it. Otherwise, we're going to sit here until I don't know when.
Madam Chair, it's not going to look fair.
No.
Can I just make my submissions on it so that I will move away if you insist that I should not ask him these questions. Mr. Arendse specifically said that he is not done with this cross-examination.
No.
He specifically said it, and the record will show that that's what he did say.
We have agreed. It really is neither here or there what Mr. Arendse wanted to do. It is what we have agreed on. We have agreed that if any new issue arises during re-examination, Mr. Arendse or the parties will have a right to cross-examine on these new issues which are introduced during re-examination. We have not agreed that Mr. Arendse may continue with his cross-examination as he deems fit.
That is not the idea. there was no open-ended attempt to cross-examine him on anything. There are specific allegations which I believe are very pertinent for the inquiry's attention. A witness comes in and says the NPA is being used to advance certain political ends. That he is not questioned on it. He doesn't give an answer on it. And the panel says, no, it's okay. And at the end of it all, we would be compelled to suggest to the panel that the reason it was not asked is because Mr. Arendse did not finish his cross-examination. And that's the reality of the situation.
Might be a reality, but that was not part of our agreement.
I understand.
Yes. Okay, just give Advocate Moroka a chance. She wants to raise something.
And I'm sorry I keep wanting to interrupt between the two of you because, and I accept that the chair and your understanding, I want you to listen to me, they must stop disturbing you, that the chair and Mr. Arendse might have differed in their understanding of her ruling. The issue that I wanted to raise with you is at some point during the cross-examination by Mr. Arendse, he specifically asserted or questioned the witness about the fact that he makes bland allegations. He's not able to factually support the allegations that he makes. It's opinions and suppositions and what he perceives to be the correct thing. And all that falls under the rubric of what you're attempting to do now, is that in fact Mr. Arendse specifically made those allegations that the things that are contained in the affidavit by Mr. Hofmeyr, some of them have no basis in fact. And I think to say that he didn't cross-examine on these issues would be incorrect. We do know that he specifically directed him to those things where he says, you're unable to support what you're saying in your affidavit.
No, my recollection is that when he made those conclusions, it was based on him having gone through the judgment in the Zuma matter and the criticism that that judgment levels against him. He did not go to specific paragraphs of his affidavit to flag out the question that I just asked. And the question I was going to ask, had I been permitted to go ahead and ask those questions. So I know that he said that given the allegations that he made relating to political meddling and all that were simply not borne out by evidence. And that you're correct that he did say that you make allegations, generally you make allegations that are just wild with no supporting evidence. But he did not actually go to the specific paragraphs of his affidavit to show up that particular observation by specifically requiring the witness to provide evidence of propositions that he makes that have far-reaching consequences for how the NPA is essentially viewed, which I think would have been important for the panel to traverse.
The difficulty is, as I see it, and that is why I think you were not happy with me when I said to you, we're not going to be able to traverse and re-cross-examine. That I don't think we're able to agree to. And I get it that you are able in argument to raise these issues that where there is no factual evidence to support what has been said in an affidavit, we must disregard it. I think you're able to do that. But to say to us you're going to go through Mr. Hofmeyr's affidavit because Mr. Arendse never got to it to cross-examine, I think that would be taking us, we have no indication, for instance, how long that would be. We're not sure why we would be permitting Mr. Hofmeyr to go through all of that again.
No, as I say, I mean, you say through it, I'm making Mr. Hofmeyr go through that again, but it was never asked. He was never taken through allegations of his affidavit in which he says that the NPA was used to fight factional battles of the ruling party. He was not asked about that question. He was not asked about the question that I was going to ask him, the second question, which is related to that. But I mean, I accept that that's how the panel feels the proceedings should be regulated at this stage. Can I then take instructions from my team on how I can proceed? Because it may well be that my team says, no, don't take it ahead.
do that, I think let's give Ms. Bauer an opportunity to respond.
Page 30 of the transcript of the 6th, Advocate Arendse reads from paragraphs 33 to 50, pages 453, 454 of the answering affidavit, to which Advocate Hofmeyer responds, Godam, Dramat, etc. It's in the transcript.
I'm afraid that is my recollection too. I wasn't specific about it, but my
Sorry, I don't know what
recollection
Ms. Bauer is referring to. I have no document on which
Me
to,
too.
yeah, in which to suggest that is the case. But I know for a fact that Mr. Arendse did not ask him the question I am asking him.
But you don't have the running transcript.
No, I don't have that running transcript.
You see, the difficulty is that you had an opportunity to cross-examine. You cross-examined. Whether or not you didn't ask a specific question might arise from the fact of how you arranged your cross-examination. After you had done your cross-examination, we have re-examination. And before we went to re-examination, Mr. Arendse asked specifically that he would like to cross-examine on issues which are new, which arise from re-examination. And that is what we agreed. So unless an issue arises from re-examination and or an issue which is normal, and or there is a new issue introduced, you may not cross-examine on aspects of evidence that you had not cross-examined on. Surely. What we focus on now is on issues which arose anew during re-examination.
May I then
And you may certainly cross-examine on those issues.
May I then take instructions from my
But before you do that, I'm worried about the fact that you say you don't have the transcript. Unless, as usual, what I suspect is that your knowledge of computers is the same as mine.
No, mine is a bit more improved. But I certainly don't have the transcript that Ms. Bauer is referring to. But that said, you've
don't
made
have
a
it
ruling.
at all, because they were made available every day at the end of the...
We would after this ask that this transcript be sent to us more regularly than they've been. But given a ruling, I don't really want to go back to the issue. You've made a ruling that I can't ask these questions. So can I proceed to take my instructions and then decide whether to proceed or not?
You may do so.
Thank you.
Mr. Rib, while they are doing so, can I confirm that you have the transcripts?
Ma'am, I haven't seen the transcripts either. I've been told during lunch that they're apparently now in the Dropbox. Because they were being emailed to us originally. I haven't received an email with it for a while, and when I inquired at lunchtime about the transcript, I was told it's in the Dropbox, but I suffer from a similar disability to easily access the Dropbox.
So there's a folder O in the Dropbox. I do recall having asked our secretary to email transcripts to the parties, and at some point there may have been a lapse in that. I will reiterate that instruction, but it is on O. If they can get to folder G, they should be able to get to folder O. There was, I think, a day or two lull, and it's been updated, but certainly the day in question has been there and was posted yesterday, I think.
In question, remind us again, was the 6th.
Was the 6th, and I was referring to page 30 of that transcript.
Thank you.
There are a number of questions, short questions that I can ask if the panel permits me.
as long as they fall within the rule.
I understood the
Thank
ruling,
you.
ma'am. So I will confine them to that. Mr. Hofmeyer, you in re-examination, you made it abundantly clear that your understanding of the law is that the deputies, deputy director of one province can be asked to prosecute in another.
I didn't say it's impossible, but it involves a procedure to get them appointed in another province formally.
Also, you accept that it's possible.
Yeah, but the minister needs to make the appointment, change the appointment from one province to the new province.
And it's true because the appointments in relation to I know I quickly said it's true, but what I was going to say to you is that when Masana took over as NDPP, and when Sean Abrams took over from NDPP, were there any changes made to those to those deputies who had been assigned to prosecute cases across their provinces?
You mean deputy DPPs?
Yes.
Yeah, not that I can recall, but there may have been. I just don't recall.
We can put it more positively. None of them were revoked. None of those deputies were withdrawn on the basis of the point you make, which is that they are not allowed to do that.
Sorry, which deputies are we talking about in specific?
In the Poison case, the same team that was put together is still the team that is going to prosecute. Mr. Sean Abrams did not tamper with the team that is going to prosecute Poison. In fact, as recently as October, when the Poison matter was argued before Judge Lopez, Mayema argued in the matter. And the matter, it was a matter in which Poison wanted to strike off the roll, but the matter was postponed to the 4th of October 2011. So the matter is still coming, 2019, sorry. And the matter is still coming. Sorry?
You said 2011, you meant to say 2019.
I meant 2019, yes. I'm a bit...
Yeah.
I can't say I was particularly aware of that change at the time.
Yes. And then... So when you say that it is not permitted, it is not permissible, you're not exactly speaking from knowledge, because the situation that you say is not permissible still exists today, and it's been in existence with 2 national directors of public prosecution that have come up since Advocate Jiba was involved.
When I say permissible, I'm talking in terms of the law. But in those cases, whatever they are, I don't know whether the formalities were gone through or not. But where I know that they haven't, I've raised the issue.
We're comforted by your lack of knowledge on it. I think it does help us assess whether or not the evidence you've given here is of any assistance to the panel. You don't know, so we are telling you what the situation is. And then the last...
Sorry, can
You want to answer?
I'm saying I don't know unless the NDPP makes an announcement or tells us that he has moved as deputy director to prosecute in another province. I don't know if it's happened unless I read about it in a newspaper. And at that stage, if I have a concern about whether it was done in accordance with the law, I would raise it with the NDPP.
Yes. And you can't tell this panel that that's what you have done? Because you don't know.
I have raised it when the issue came up with the relevant NDPP and when I was aware of the situation.
Sorry, which one are you referring to now?
I think the first issue was in relation to the Zuma team at the beginning, when people from different provinces were brought together to do the prosecution at the national level. I think the issue came up in the, sorry, I don't want to try and recall things, but the issue has come up at least 2 times, perhaps 3 times over the years, apart from this specific issue.
Lastly, subject to what instructions I'm given, am I correct that in your view, and which is confirmed in your affidavit, is that the Boyson matter, that there is no evidence in the Boyson matter on which Advocate Chiba could have issued an authorization?
What I gave evidence about today is what was reflected in the minutes of meetings of the NPA.
Yes.
And which minutes were not corrected afterwards if they had been captured what was being said incorrectly.
But so I want to put this proposition to you, that at no stage has any member of the prosecution team ever considered that there is no case against Mr. Boyson. There's not a single member of the prosecution team who believes that there is no case against Boyson.
Then I assume the concessions were made in the EXCO meeting by Mr. Chauke or Ms. Jiba or somebody who was involved in the prosecution.
Sorry.
But if it was recorded incorrectly, then it should have been corrected at the next meeting.
Sorry, I'm not sure which meeting you are referring to in which a concession was made. Can you refer us to a meeting? I'm not sure if anybody has that information, because I haven't seen it, and you certainly have not brought it to our attention.
So one of the minutes of the meeting is 2 March 2015.
2 March 2015, okay. So
The item is 6.5.
Okay.
The NDPP informed EXCO that he met with some of the advocates to brief him regarding the status of the matter. That's Kato Mana Boyson. After the previous EXCO, they have informed him that the prosecution team is still looking for further evidence. They further informed the NDPP that so far no evidence could be obtained against General Boyson.
Yes. That is this is not, I'm told that this is not the prosecution saying so. That's not the prosecution. Incidentally, who was the NDPP at the time?
Mr. Ngasana was the NDPP.
Yes.
As I said, the people who were at the meeting, I think includes Ms. Jiba. So if it was incorrectly reflected in the minutes, then it should have been corrected.
Sorry, you know that Ms. Jiba was not the prosecutor, right? In the Boyson matter.
I know that she wasn't,
Yeah.
but I think she was familiar with the facts and the situation around the initial
So-
processes around that prosecution.
So do you still persist in your allegation that there was some concession made by the NDPP that there was no evidence? Oh, sorry, by the prosecution team that there was no, that there is a, do you still persist that as far as you're concerned, there is no evidence on which the prosecution of Boyson could be persisted with?
My understanding from my personal knowledge that Mr. Ngasana had given me similar feedback. But what I'm giving evidence about here isn't what I heard from him, it's what's reflected in the minutes of a meeting.
Yes.
And if it is wrongly reflected, it's a very serious issue that I would have expected, even if it's sometime later, that somebody would seek to correct it.
Yes. Is there anything else? Finally,
Perhaps,
At
can I
the-
just add to what I just said with the indulgence of the Chair? I mean, I think my conclusion is bolstered by the fact that throughout this period there's an outstanding item that says report to the NDPP on the Boyson's matter is outstanding.
Mr. Hofmeyer, no matter what your belief is on the Boyson matter, your personal belief, the matter is before the courts. Mr. Boyson will face his justice one day, no matter what your belief is. The prosecutors are busy on it. They are working on it. As I said to you earlier on the 4th of October 2018, the matter is coming before the courts. Sorry, on the 19th of October 2019, the matter will be running. She doesn't write properly, so I'm having difficulties reading her handwriting. So 4 October 2019. You got that, Mr. Hofmeyer?
4 or 19?
The 4th of October 2019. So the matter is proceeding. It doesn't matter what your belief is about Mr. Boyson. I'm putting it to you that whatever you say about Boyson, and it seems to me that you are quite keen to have him protected, it's not going to happen.
I
The
thought
matter
we
is
were-
going on.
I thought we were discussing the minutes.
Oh,
And,
no,
what and what stands in the minutes.
Yes, so I just wanted to assure Mr. Hofmeyer that whatever his views are on Mr. Boyson and what he says about the prosecution team, it doesn't matter because the matter is in fact still live, it's still running. So whatever he may have thought of the issues before, it doesn't matter. The minute is irrelevant for that question.
What do you mean the minutes are irrelevant? We've been discussing the contents of the minute and the question whether there was sufficient evidence or not.
No,
Why
you
did
see, the witnesses, I understood him, he was seeking to suggest that there was a concession, that there was no evidence against Mr. Boyson. And in
That's
order to
what we were
bolster
discussing.
that submission, he referred us to that minute. So what I'm putting to him is based on his response to the issue of Mr. Boyson, because he would like it known that somewhere in the system, people don't believe that Mr. Boyson is not going to face justice. But I'm just putting it to him that is an imaginary situation, because the reality as we speak now is that Mr. Boyson will answer the charges against him.
It's fine.
Is there anything else?
We're waiting for your answer, Mr. Hofmeyer.
Sorry, I thought the Chair was shutting down.
Got to respond. He put a statement to you. Respond to the statement.
Let me say that I have no knowledge of what he is saying. It may well be that the decision is taken. I've not been briefed about it by the NDPP or whoever is dealing with the decision. And I'm sure the courts will come to the right outcome as they usually do. I'm not saying anybody should be protected from prosecution, but the indications were at that time that there was not evidence on which to prosecute somebody who was being prosecuted. I think that's the point of my evidence.
Well, it's just that my scope of cross-examination is limited. I would put something to you that I will be stopped from putting. But let me put it this way. The final proposition I want to put to you. When Mr. Jiba takes a position, sorry, when Advocate Jiba.
No, I must object. What did you say? Missed it.
I said, it was a mistake. I apologize. She has already chastised me for it.
Okay,
Yes.
well, we are
Can
also
I
doing
be
that.
spared? Yes. when Advocate Jiva takes a stand and speaks for herself, she will explain to the panel exactly what happens with the authorization that she dealt with. She says, to put it to you, that you're out of touch with the process that is followed when the authorizations are done. That even as today, as you speak, Mr. Advocate Musing is still responsible for the for placing authorizations request before the NDPP. Even today, there is no committee that you testify to. It has never existed as far as she's concerned. And when she speaks, that's what she's going to put to the panel.
I can only say that what I gave in my testimony was information I received from somebody who was part of the committee at the time. I know he's no longer part of the committee, but at that time he was supposed to be part of the committee.
We understand it's from hearsay. Honorable panel, I have no further questions.
Thank you, Mr. Masuku. Mr. Rep, your
Ma'am,
turn.
just two small aspects, since my colleague's not here today, if I could just deal with two aspects. Mr. Hofmeyr, before I deal with this minute, I'm going to put a proposition to you that I'm going to argue when we get to dealing with the evidence, and that is that throughout your evidence you have displayed the manner in which you've answered the questions, the manner in which you have refused often to answer the questions, the manner in which you've obliquely answered the questions, have all shown to me and demonstrated, and I shall put it to the tribunal, that you have got an agenda to be here, you've got an axe to grind with the National Prosecuting Authority, and you have an axe to grind with Advocates Jiba and Mwebi, and that your evidence really is severely diluted because of the manner in which you've chosen to present the evidence. You can comment on that if you wish to.
I wish to say very strongly that I have no axe to grind with particular individuals. I do have an axe to grind about the integrity of the NPA and ensuring that the NPA functions with integrity. And I have taken that issue up several times in the past. If you think there's no objective, or at least evidence of the impact on what has happened on the image of the NPA has done regular monthly reports on how it is perceived in public and in the media. And we have hit some of the lowest points in the history of the NPA in terms of what people think about the NPA, what the media reports about the NPA. And I think even the President himself has acknowledged that there's been a crisis in the NPA. So the perspective that I come from is that I've lived through that crisis. And I'm desperate for the NPA to get fixed and to do the job that the Constitution demands that it should do. For that, I'm willing to go through many days of cross-examination and nasty questions. but I do think it is vital that the NPA be fixed, and I think this inquiry is part of that fixing process.
Fine. And can we go to paragraph 6.5 of the minutes we were looking at? Because you used this paragraph to indicate that this minute shows that there was no evidence against General Boyson. Can I read to you what it says? First of all, it appears to be the National NDPP who is speaking himself. Is that correct?
That's correct.
And he's reporting what he's been told by other people who are
No,
not at
he's
the
reporting
meeting.
on what he's been told by some of the advocates who had participated in the Boyson's matter and who had briefed him.
Is that not being told by other people? That's a classic example, Mr. Hofmeyer, where you simply refuse to make the most simple acknowledgement and concession. I say to you, he was told by other people. Your answer is no, he was not told by other people, he was told by advocates. And that is how you split hairs and have obliquely and patently refused to deal with the questions and the issues that have been placed to you for a week now.
I think he was told by prosecutors who were involved in the matter.
Yes, and then...
And as
Sorry, sir.
and the NDPP is entitled to be briefed on cases and to ask questions, and this is the report back that he gives to his management team from that meeting. If you don't, it's formalized in the minutes, it hasn't been challenged, nobody said please change the minutes, it is not accurately reflected. So, and it accords with my own recollection of what he said at the meeting.
You finished your answer. That still doesn't answer my question. I didn't ask you any of those things. I didn't make any of those suggestions. I simply said he is informing the meeting of what he was told by other people. Now, for minutes, you've gone on about other things. But let's leave it there. I'll argue it in due course. Let's have a look in the second line. They have informed him that the prosecution team is still looking for further evidence. You see that line?
I do.
And if you're looking for further evidence, it means you have evidence. You're looking for more evidence. That is the normal English grammatical meaning of that sentence. It doesn't mean I have no evidence, I'm now looking for evidence. I'm looking for more evidence. Is that not correct?
I accept that that is correct. I mean, what is not reflected or unclear in the statement is whether there was already enough evidence before the looking for further evidence, or whether there wasn't enough evidence before. But I'm not contesting the meaning. I agree that he had said that he would like more evidence, and the prosecution team is looking for more evidence.
Yes, but when you referred us to this, you didn't say it's because they were not sure if they had enough evidence for the prosecution. You used this as the statement that there was no evidence against General Boyson.
But with respect, I'm sorry to interrupt you. You must then read the next sentence as well.
I think
I
read the
will
whole
get
of,
to the next sentence,
read the
ma'am.
whole of
I will get to the
6.5.
next sentence, ma'am.
Not just the next sentence, the whole.
Because the next sentence says, they further informed the NDP that so far no evidence could be obtained. Now clearly, you must read it in the context, ma'am, and I'll argue this, that when they say no, so far no evidence, they're referring to the further evidence they're looking for. I say I'm looking for further evidence, and I say so far I've found no evidence. It cannot be that I've got no evidence from the start. The no evidence there that's being referred to is clearly and unequivocally in context the further evidence that they are speaking about. It does not take away what would have been there before. With respect, ma'am.
Yeah, no, it's okay. You'll raise it
I'll
during
argue.
your argument.
In any case, the last thing I want to put to you is that you said to us that there's no evidence. This was an example, and now you're saying it goes about whether or not there was enough to prosecute. And these 5 minutes, with respect, have demonstrated the way you've answered the questions for the last week or however long you've been here, because I missed some of it, and supports and buttresses the supposition I put you right at the start. You can comment on that if you wish to.
I think I have already commented on that. Thanks, Chair.
Thank you, Tribunal. I thank you, panel. We have no further questions for the witness.
Thank you so much, Mr. Rip. But before we sign off, Ms. Vilakasi would like to ask a question.
Just for clarity, when we speak about the Boyson case, are we speaking about the case against Boyson only directly, or do we speak about the bigger case in a sense that if you read the minute, when we say the subject, as I said, Boyson, encapsulates all the other people that are charged in respect of the entire case? Or if we just say Boyson, are we just saying Boyson and then everything that has to do with that case just relates to that specific individual?
I think the heading sort of reflects that there's a Cato Manor case and a Boyson case to some degree, because I think they are slightly separate. I don't think there's real contention about some of the allegations or evidence that there was against members of the Cato Manor team. But I think there was a separate issue about the extent to which those things could be ascribed or were ascribed to General Boyson. I'm not sure I'm making it clear, but I think that's kind of why I don't think anybody was arguing about the merits at that time, about the general allegations against the members of the Cato Manor team. The contention was whether there was evidence about General Boyson in particular.
Thank you, Mr. Hofmeyer.
I want to just deal with housekeeping.
No, I think let's release Mr. Hofmeyer. Thank you so much. Thanks for your assistance. Together with your legal representative, we appreciate it. Okay? You may stand down. Ms. Bauer, housekeeping.
Housekeeping. So I've discussed this with my colleagues on the other side, and the plan is to try and start punctually at 9:30 on Wednesday, and then take it on Thursday and Friday, whether we need to even go earlier, to have a reduced lunch adjournment. And then the plan is that Advocate Rip would start with Advocate Mokgoro on Wednesday. If he finishes close to the end of the day, then that's the end of the day. If he finishes with some time to spare, we would then run on. So we'd run as a continuous roll as best we can, because we're trying to build in some time for re-examination at the end. Yeah, to do that.
Thank you then, everybody. And housekeeping says kindly, promptly, tomorrow.
Wednesday. I'm already consulting
we should
tomorrow.
try that. we should actually try that. You know, if we're running out of time, we might just have to do that. No, on Monday, sorry.
No.
On Wednesday, yes. Promptly, kindly, yes. Assist us. Thank you. I'm tired. Can I thank you for your contributions during the week? In fact, up to now. We hope that we will run the course as smoothly going forward. But I think we're getting there. But thank you so much, and have a good weekend. See you on Wednesday at promptly 9:30. Thank you.